Welcome back, everyone. In this lecture, we're going to spend some time exploring common criminal defenses that are used to explain away criminal liability. These are not always successful, but the defendants still have the right and ability to defend themselves against the charges that were brought forward by the prosecutor's office. We are going to work our way through things like self-defense, age, and intoxication as defenses. Some of these can become quite complicated at times, so I hope you're following along with the textbook and with the examples that are provided by the authors. Let's get started weeding our way through these different types of defenses. In our adversarial court system, I am innocent until you prove me guilty. I don't have to do anything to prove my innocence. You, meaning the prosecutor, just have to do an adequate job to prove my guilt. This means that the government is responsible for finding evidence, providing witnesses, and tearing down the defense that the defendant presents. The defense team also gets to do all of these things. In an adversarial system, it goes both ways. That's why we have things like cross-examinations and discovery sessions. That being said, everybody smart builds a defense for their case. Part of the defense is to respond to the state's evidence. Just like the state is trying to tear down the defendant also needs to tear apart the state. That's the best thing about the adversarial system that we find ourselves in. It's always a fight. The only time the burden is not on the state is when an appeal takes place. The state did their job the first time around by securing the conviction. The defendant now takes on the role of trying to prove the state wrong. The burden is now on the appellant. When we discuss affirmative defenses, we typically address two different types: justification and excuse defenses. In both of these styles, no one is really proving that they didn't commit the crime, but they might outright deny that they are the one responsible. I didn't pull the trigger, I wasn't there, you don't have enough evidence to convict me. But other times, there is a certain level of admittance that the defendant did commit the crime, but they are still not guilty for the specified reason that they provide in court. The defendant is responsible for proving the defense. The defendant has the burden of production or of persuasion. In using justification defenses, the defendant is trying to explain that his behavior was warranted given the circumstances in question. This means that the defendant has to provide some sort of evidence in support of his defense. For example, I am not criminally liable for the victim's death because I was justified in my actions. Yes, it's generally wrong to kill somebody, but they broke into my house in the middle of the night and I had to shoot them in self-defense. It wasn't wrong for me to break out of prison because the other inmates were threatening to kill me. These are just some examples of justification defenses. On the other side of things, excuse defenses show that the act was terrible and yes, it should be a punishable offense, but there is something about my personal circumstances that should excuse or negate my liability. For example, I am not criminally liable for this murder because I suffer from a mental illness. I was under the influence of narcotics at the time of the crime. I had a really bad reaction to this medication and I couldn't control any of my physical actions. I'm not arguing that I didn't commit the crime, just that I'm not liable for it. Now we're going to explore defenses on an individual level, beginning with the insanity plea. If the defendant is going to try and use the insanity defense, then it's up to the defendant to prove that they are insane. The court will assume that you are sane until you prove otherwise. Typically, this is going to be done in stages. The defense has to meet specific criteria provided by the state to prove legal insanity. The common perception of the insanity defense is that it's pretty easy to achieve and it could serve as a fallback if the state has a strong case against the defendant. But in reality, it's very difficult to actually achieve the insanity defense. By proving legal insanity, you might prevent yourself from going to prison, but you're still going to be institutionalized somewhere. So you're not going to be free, you're just swapping out one building for another. But things like the death penalty would not apply here. So you would be able to skirt certain punishments like that. But you just can't plead insanity at your trial and be done with it. There is an entirely separate hearing called the civil commitment hearing that takes place to determine whether or not your plea is valid. So why is it important to have a separate review hearing for the insanity plea? Well, for one thing, we don't want this to be an easy go-to solution for those who don't want to go to prison. But on the other hand, we also want to make sure that those who are deemed legally insane are not being punished for their lack of free will. Many think that it would be cruel to seek retribution against those who are unable to control their actions. But if they're really legally insane and they are dangerous, we still don't want to make sure that they have total freedom. This is a type of individual who still might pose a danger to society and thus is going to need some sort of professional treatment. Therefore, we have the commitment process. For these reasons, it's important that the defense plea is examined separately. As I said before, it's often difficult to achieve a successful insanity plea simply because most states use a variation of the McNaughton rule or the right and wrong test. The McNaughton test has been around since around the 1840s when an English defendant by the name of McNaughton was acquitted for the murder of a man who McNaughton mistakenly thought was the British Prime Minister at the time. There are 6 elements to the McNaughton test that have to be proven by the defense. The first is a presumption of sanity and the burden of proof that the defendant is actually insane. Sanity is a rebuttable presumption, and the burden of proof is on the party who is denying it. The standard of proof is on a balance of probabilities. That is to say that the mental incapacity is more likely than not. If this burden is successfully discharged, then the party relying upon it is entitled to succeed. This doesn't mean that the defendant has an extensive history of mental illness or even suffering. What this does mean is that at the time of the offense, the defendant was suffering from something that did not allow him to distinguish from right from wrong. Next, the defendant must prove that there was a disease of the mind at the time of the offense. This means that it could be something like postpartum depression that becomes so severe that I end up killing my child. It doesn't have to be strictly a brain disease. It seems that any disease which produces a malfunction of the mind is a disease of the mind and need not be a disease of the brain itself. Things like epilepsy, diabetes, and even hyperglycemia have all been used successfully to show that the disease has affected the brain. The defendant must also overcome the nature and quality of the act. The defense covers any situation in which the defendant does not know that he or she is what he or she is physically doing. Normally, this is only used in severe crimes because it wouldn't make sense to plead insanity for something as simple as a traffic charge. For example, a woman thinks she's cutting a loaf of bread to make a sandwich, but she doesn't realize that she's cutting her husband's throat. Or better yet, the defendant cuts off his roommate's head because he thought it would be funny to watch the roommate look for it when he woke up. These are actually 2 real-world examples in which the insanity defense was used successfully. The defendant must show that the act was wrong. This is actually a tough one because the offender might not be aware of what they were doing, so how would they know what they were doing was wrong? Go back to the loaf of bread example. If I'm delusional in thinking that I'm simply making lunch, then I don't believe what I'm doing is something that's wrong. I could still be thinking that murder is wrong and against the law, but in my mind, that's not what I'm really doing. Under this interpretation, there may be cases where the mentally ill know that their conduct is legally prohibited, but it is arguable that their mental condition prevents them from making the connections between an act being legally prohibited and the societal requirement to conform their conduct to the requirements of the criminal law. The insanity defense is only applicable to crimes without specific intent. You cannot use the insanity defense for strict liability crimes. This means that it's inappropriate for crimes like DUI or vehicular manslaughter. If I drink and drive and kill someone, I cannot try and use the insanity defense because I voluntarily consumed the alcohol. But if I drove my car and killed somebody because I thought that it was a flying spaceship and I was trying to chase aliens, that's a different story. Finally, we have to take into account the role of the jury. A jury should not return a special verdict that the accused is not guilty by reason of insanity except on the written or oral evidence of 2 or more registered medical practitioners, of whom at least one has special experience in the field of mental disorders. This may require that the jury has to decide between conflicting medical evidence, which they are not necessarily equipped to do, but the law goes further and allows them to disagree with the experts if there are facts surrounding the circumstances which, in the opinion of the court, justify the jury coming to that conclusion. If all of these items are in place and I can successfully make a strong argument, then I will be granted the plea of not guilty by reason of insanity and will be sent to a mental institution for treatment rather than to prison. Diminished capacity is a little bit different of a defense comparative to the insanity plea. If you thought that insanity was a difficult defense to achieve, you haven't seen anything yet. Diminished capacity is only recognized in less than half of the states to begin with. There's no legal insanity present, but something has still occurred which inhibits my ability to form criminal intent. This does not excuse me from a prison sentence. There is no mental institution alternative for me under this defense. At best, I would receive lesser charges or a lighter sentence if I was successful in achieving the diminished capacity argument. So I'm not trying to prove that I'm legally insane here, but here I'm trying to prove that there has been a disturbance in the force somewhere. This disturbance is better known as the Twinkie defense. Dan White was a supervisor who worked for the city of San Francisco. On November 27, 1978, Mr. White assassinated Harvey Milk, who was a prominent gay rights activist, and George Moscone, who was the mayor of San Francisco at the time. Mr. White was charged with 2 counts of first-degree murder, but his attorneys presented the court with the argument that Mr. White was severely depressed and as a result of that depression had been eating an abundance of sugary foods and drinks. He was eating so much junk food that it was throwing off his ability to mentally cope with the things around him. Mr. White must have had an excellent attorney because this actually worked. Mr. White was convicted of voluntary manslaughter charges rather than the first-degree murder charges that he originally faced. He received 7 years in prison, but later committed suicide after he was released from his incarceration sentence. Switching gears a bit, we're going to focus on more common defenses that are a little bit easier to achieve. The next 2 are focusing specifically on intoxication, both voluntary and involuntary. Voluntary intoxication, meaning that you are the one who drank the beer or you used the illegal substance, does not have a legally recognized defense attached to it. You cannot completely mitigate the crime. You can still make defensive arguments to get out of the liability associated with the crime, but your defense cannot be that you were drunk and you didn't know what you were doing. Instead, if you are going to try and use intoxication as a defense, it can only be involuntary intoxication. Involuntary intoxication suggests that you have not consumed the substance voluntarily, but rather ingested it through use of force, coercion, or mistake. There are actually 4 types of involuntary intoxication that fit within this category. The first classification suggests that you ingested a substance under duress or that you were coerced into that consumption. For example, you order a beer and you drink the beer not knowing that someone has spiked your drink with rohypnol. You can also take a substance by mistake. For example, I have a legal prescription for Ambien, which is a sleeping pill, and that should be used at night. I accidentally take it thinking that it's one of my morning prescriptions. Let's say I put it in the wrong part of my pill box. I take the Ambien, I get in the car to go to work, and I fall asleep behind the wheel, and I hit someone, and I kill them. You voluntarily took the pill. Yes, that's true. But you made a mistake, and were not trying to go to sleep in the morning. It's a mistake, and you can try and defend that mistake as such. You could also try to claim that the involuntary intoxication took place via fraud. This means that you tell me I'm taking one thing, but really it's something else. You're the one who hands me the Tylenol for my headache, but really it's that sleeping pill. Or let's say Walgreens mixes up my medications that I legally got. The label says the right thing, but the pharmacist was distracted and they put the wrong pill inside the correctly labeled bottle. Finally, you can claim involuntary intoxication through the use of the medication itself. For example, I take something that is legitimate and it's legally prescribed to me. I take the medication at the right time of day. I only take the amount that is prescribed to me, but it's a new medication that I haven't taken before and I have an allergic reaction of some sort. No one knows that I'm allergic to this medication and no one knows that I would have reacted this way, but it's happened and it's an uncommon reaction that many people don't have. It was unforeseeable and unusual, and this would probably stand as a defense under the involuntary intoxication defense standards. Next up, we have the legal defense surrounding the age of the defendant. Age really is only a concern when the defendant is a juvenile. In the colonial era, parents or guardians sometimes would accept responsibility for the punishment and punish the child themselves. There was no real need to formally have sanctioned punishments if there was a parent to serve as proxy. But sometimes there was no guardian and children were living hand to mouth on the streets. Let's say they steal something and now they're going to be punished for it. Punishments were a lot harsher during the colonial era and often included things like nailing ears to the pillory, putting children in stocks, and sometimes even execution, depending on the crime that the child had committed. We also executed very young children. Today we don't execute anybody who was under the age of 18 at the time of the offense, but our colonial ancestors were actually executing 7- and 8-year-olds. When the juvenile is only 7 or 8 years old, that's pretty young, and many people believe that it's too young to even prosecute. Under common law, children that young were not legally able to inform intent to commit the crime. We all know from previous lectures that if there is no concurrence between the actus reus and the mens rea, that the individual cannot be held criminally liable for the offense. As the adolescent develops, the court system believes that they should be held accountable the older that they get. But that age can still be used as a defense due to the fact that juveniles are not yet completely developed mentally. We now know that our brain development and the idea that juvenile offenders are, did I get that right? Yeah, okay, sorry. We now know about brain development and the idea that juvenile offenders are not the same as adults. Our brains are not fully developed until we reach about 24 or 25 years of age. So how do you reasonably convict an 8-year-old in the same way that you do a 40-year-old? It's a difficult proposition to find ourselves in, especially when we're discussing older adolescents. Things get a little muddier when you reach the teenage years. A lot of states love the idea of transferring juveniles to the adult system, and in Utah, juvenile transfer can actually happen as early as 10 years old for violent crimes. That's incredibly young and doesn't even fit within the common law requirements of responsibility and mens rea. It wasn't until 2005 that the death penalty was actually completely banned for juvenile offenders in the case of Roper v. Simmons. They were still eligible for life with the possibility of parole. So now you have to be at least 18 years of age at the time of the offense to be executed by the state. Before the 2005 ruling, the cutoff was actually 16 years old. We also know that juvenile life without parole sentences have been abolished as well, based on the court ruling of Miller v. Alabama, which happened in 2012. So now you have to give juvenile offenders the possibility of parole, even for capital offenses. That is now the highest level of punishment possible for those under 18 years of age. Next, we're going to segue into self-defense, which is probably the most recognizable and widely used defense for violent crimes. The use of self-defense can end in the death of another, but not always. For example, I could just defend myself enough until I'm safe from harm. Is self-defense okay if I'm able to get away? Should I run? Should I stand my ground? Does the location matter? What if I'm in public? What if I escalate the level of violence that is necessary? These questions are all addressed in different state laws and differ based on location and what you're defending yourself from. At a basic level, self-defense means that I am supposed to exert enough force to defend myself against a like-minded level of force. So this means that if it's simply a fist fight and someone attacks me, then it's too much to take out a gun and shoot my assailant. But if someone is trying to kill me, then it's completely justified that I kill someone to defend myself, given the circumstances, of course. Different states define self-defense differently and operate under two different standards. The subjective standard is more common and means that I only had to believe that I was under attack from someone. It also allows for situations where I might not even be under attack, but I think that I am and I react accordingly. However, the word imminent is also included in this definition. That means the attack has to happen right now, or it's going to happen moments from now. It doesn't count if someone threatens to kill you a week from now. That's not very imminent. Other states use the objective standard. The objective standard has more components to it and has more rigid elements that need to be met. But under this standard, other people would have to feel the same way about the situation, and they would have to also believe that they were under attack in similar circumstances. We begin with the reasonable belief. This means that I believe that I was under attack. For example, someone came at me with a knife in hand, but I don't know that it was actually a plastic toy knife. I just see this person charging at me, and it looked real to me. I don't know that it was a fake knife, but I saw the situation, and I reacted accordingly. But if there was unreasonable belief that then the defense is invalidated. For example, I thought the person who was trying to talk to me was an alien sent here to kill my family, so I shot him repeatedly. You cannot claim self-defense under this standard, as most people would not think that the victim was actually an alien. Was the action a necessity? Meaning that unless I acted this way, I was going to die or seriously be harmed, and this was the proper amount of force necessary to guarantee my safety, then it would be classified as a necessity. If I wasn't in a life-threatening, dangerous situation, or if I exhibited too much force, then this would not be considered a necessity under this standard. The last statement ties into the idea of proportionality. Was the amount of force employed too excessive given the circumstances? Say, for instance, we get into a verbal altercation, which leads you to punch me in the face. After being punched, I felt threatened, and I take out a gun, and I shoot you dead. You didn't have a weapon, and you only punched me in the face once. The amount of force that I used was too much given the circumstances, and I would not be able to claim self-defense here. I have to match force with an equal display of force. I also have a duty to retreat if I can at all. Depending on state laws, there may be a requirement for the individual to retreat. Normally, it's not required in the home or in the workplace, but in other instances, retreat may be required, meaning that you should actually have to retreat to the wall. We also have to question who is the aggressor in all of this. The aggressor does not have the right to self-defense, with one exception. If you escalate the amount of force needed to defend yourself, you have now turned yourself into the aggressor. If you have become the aggressor, then the original aggressor now has the ability to defend himself against you. So going back to our previous example, if I punch you in the face and you take out a gun and you try and shoot me, I now have the right to defend myself against that if you don't instantly kill me. Some courts recognize that if I retreat from the crime and you still come after me, that I now have the right to self-defense. You became the aggressor because you pursued me after I had fled. States also take into account mistakes. For example, if I mistakenly believe that I'm in danger and I need to defend myself, I have the right to do so. All of the other same elements still apply to mistaken situations. Finally, our last defense of the day rests with the issue of entrapment and the government's role in trying to get you to commit a crime. This is where the government steps in to try and get you to engage in a crime that you could argue I would not have committed if you didn't set me up to do it. Entrapment is often highly criticized by citizens because people protest about the setup of it all. We see a lot of undercover sting operations or police who are lying in wait to catch folks. One of the big ones is the idea that police are waiting outside of a bar, hidden to see if you're going to drive home drunk. Prostitution is another area where entrapment is often used. Let's say I'm an undercover officer and I pose as a prostitute or a high-end call girl. The government likes to use entrapment for a variety of reasons, but some of the big ones are really listed here on your screen. First, we see that it aids in crime detection, meaning that entrapment is often aimed at those crimes that are difficult to detect, like prostitution. Street prostitution is very highly visible, but what about indoor or internet prostitution? That's a little bit more difficult to detect. Entrapment also doesn't waste many resources like other forms of crime detection. Undercover stings often don't cost a whole lot of money and can yield high volumes of arrests, especially since they don't need many officers or specialized equipment to do so. Finally, law enforcement claims that there is a high level of deterrence embedded into sting operations. For example, you might not be willing to solicit a prostitute if you thought there was the possibility of her really being an undercover officer. Even though entrapment is pretty clear on what is done to entice the offender, there are still two tests for entrapment in terms of what the government's role is and how they entrap. In this subjective test, we have the government on the right side because they are trying to fix the problem that is growing rampant. So again, let's say we have a prostitution problem and this sting operation will help decrease that problem. It's fine to have a prostitute on the street. If I, as the John, am the one who is approaching her, then that's my fault. I was already in the area looking for a prostitute to solicit anyway. This one just happened to be an undercover officer. This test isn't about the defendant at all, but is actually all about the improper use of government action. Some examples of improper government action are supporting the entrapment defense, which include excessive financial inducement, sexual favors given to the accused, and exploitation of emotional problems of the accused. Some actions are objectively seen as the government going too far in creating crime rather than trying to detect it. The government is really seeking you out rather than letting you come to them. In this lecture, we focused on a variety of different defenses, beginning with the insanity plea, self-defense, age, and even entrapment. Just because these defenses might be available to the defendant doesn't automatically mean that they're going to be successful. Instead, the defendant is not successful. They might actually end up hurting their chances for acquittal in the eyes of the jury. Next time, we're going to begin the exploration of individual crimes as we turn our attention towards homicide. I'll meet you back here then to start our exploration of murder. See you then.